Welcome to the second deep dive of the Cowichan case and why your title might be deemed defective. In this video, I'm going to expose the 3 legal ticking time bombs buried in the new Cowichan decision that can make your property deed defective, and exactly what you need to do before your bank finds out. Number 1 is a logical impossibility, a legal paradox where 2 different legal systems, so 2 people can legally own your house exclusively at the same time. Number 2 is the death of the torrent system, meaning that the government no longer can guarantee your title, and your title might be worthless. And number 3 is a quiet mortgage meltdown that is already causing renewals to be rejected in Richmond right now. I'm going to unpack these 3 disasters: the paradox, the broken system, and the credit freeze. Because if you don't understand why the banks are getting nervous, you won't understand why your capital is at risk. There are currently possibly 3 ways that this is going to end: through an appeal, through a possible settlement, and the nuclear option would be the change in the Constitution itself. Now, this is a long video, so it's very important that you watch until the end so that you can really find out if you own that piece of dirt that you have in Canada. So buckle up and let's get into it. First, let's set the stage. The Cowichan Tribes decision wasn't just a regular Tuesday in court. It was the longest trial in Canadian history, exactly 513 days. Over 5 years of litigation and almost 900 pages of decisions. Justice Young delivered a ruling that essentially said, yes, you have fee simple title, but the Aboriginal title that was here first, well, it's still there, and your title is now defective. Now you might think, well, okay, Richard, this is a legal jargon. It's just going to pass over. It doesn't really mean anything. But as Ozzie Jurock pointed out, and John Weston, this isn't just jargon. This is constitutional. And it's a constitutional first. It threatens the bedrock of how we buy and sell houses. And to understand why, we have to look closely at these 3 massive problems that I mentioned at the start. The problem number 1 is a logical impossibility. Let's dive deep into that one. We operate under a system called fee simple. That means you own the land exclusively. No one else can come in and tell you to paint your fence pink, or that you can't build a shed, or that you can't change your roof. It's essentially yours. But Aboriginal title is also defined as an exclusive right to the land. So here's the puzzle that is brought up. How can you have 2 exclusive owners to the same thing? Imagine you have a car. You have title to that car. You think you own it exclusively. But then the judge says, actually, your neighbor also owns this car exclusively. And the questions that comes to mind would be, well, who drives the car? Who gets to sell the car? Who gets to put gas in the car? And, well, who gets to pay for the maintenance? Who gets to maintain it? And, well, you get the picture. Therefore, as the legal expert Thomas Isaac said once, you can't really have 2 exclusive rights to one thing by definition. So the court has actually ruled that both exist simultaneously, and that's a paradox. This isn't just a legal gray area. It's like saying that a door is both open and closed at the same time. In the market, well, the market really hates paradoxes. You can't really price a paradox. Now, the second problem that we have is the death of the torrent system in British Columbia, and perhaps even in Canada. This leads up directly into problem number 2, the breakdown of the system that we trust. You see, because in BC, we use something called the torrent system. It's the Land Titles Act. It's the reason why when you buy a house, you don't need to research 500 years of history yourself. You rely on the registry. The government guarantees that title. It's supposed to be indefeasible, which is a fancy word for unbreakable. But Justice Young ruled that Aboriginal title lies beyond the torrent system. She declared that crucial section of the Land Title Act, the guts of the private land ownership, do not apply to Aboriginal title. Therefore, your registered title, that piece of paper that you have in the safety deposit box, it might not be worth the paper that it's printed on. As John Weston and Ozzie put it bluntly, it may just be your registered title that you don't really own. If the Land Title Act doesn't apply, then the guarantee doesn't apply. And if the guarantee doesn't apply, then what exactly did you buy? This is a breakdown of trust. The system was designed so that you didn't have to worry about this. Now the court says you do. The third problem is that there's currently a mortgage meltdown happening in Richmond right now. If you think about it practically, this problem is where it hits the wallet the most, which is market uncertainty. As Ozzie mentioned in the town hall meeting in Richmond back early in November, 600 properties owners showed up. And can you imagine the tension in the room when 600 people wondering if they really own their homes? And one landowner actually stood up and he said, I'm running into problems renewing my mortgage. Now think about it from a bank's perspective. Banks are usually risk averse. They lend you money because they can take the house if you don't pay, to put it bluntly. But if the title is defeasible, then it can be broken and your collateral is risky. Therefore, the lender will most likely not want to lend or renew your mortgage. If you are a lender, what interest rates do you charge on a house that might belong to someone else? Do you lend at all? This is an excellent question. Therefore, we're seeing a lot of credit tightening at the moment. And so we're seeing banks asking these questions and asking questions they have never asked before. This is why I mentioned earlier that $85 billion in capital fled Canada in the first half of 2025. Money usually goes where it's treated well, and right now it's being treated like a paradox. Canadian real estate is treating money very, very poorly. So here's the biggest twist in all of this. You may think that the government committed a mistake when they were arguing in court, but in fact, it was actually the opposite. They were very well aware of what they were doing. You might be screaming at the screen right now and saying, well, why didn't the government fight for this? And here's a twist. This is the part that made my jaw drop when Ozzie mentioned it. John Weston, the constitutional lawyer, pointed out something unbelievable. At the trial, the province of BC and the federal government surrendered their most effective argument. They did not argue that the Aboriginal Crown grants extinguished Aboriginal title, because according to Weston, David Eby, back when he was Attorney General, issued a civil litigation directive. That basically means that he ordered the government lawyers not to make that argument. So David Eby ordered the government lawyers not to make the argument that our fee simple title overrides basic Aboriginal title. Therefore, this wasn't a mistake. It wasn't an accident. It was a policy choice. And the government chose not to defend the concept of fee simple title. Only the city of Richmond, the small little city of Richmond, was the one that made the argument. And here's the kicker. Because the province didn't argue at a trial, it is very hard to bring up that case on a court of appeal. You can't change your strategy just because you lost. So they may not be able to bring that argument in the appeals court. So you may be wondering, how does this all end? We are in a big mess, and how do we get out? As Ozzie outlined, there's possible 3 outcomes that may come from this. The first is the appeal, and everyone's appealing. All 7 parties, including the tribes and including all of the provinces and the city of Richmond as well. But as I told you, the province tied its own hands by not making this key argument. This appeal process could take 5 years. And that's 5 years of you wondering if you own your home or not. And 5 years of banks being nervous. 5 years of bank not lending. The second possible outcome would be a negotiated settlement. And this would be something like a kumbaya. Everyone gets together in a room and they work it out. But if you look at the track record, everyone getting in a room and working it out didn't really work out. In fact, we've been at this for 5 years. The BC government tried to constitutionalize the Haida Agreement, for example, and that created more confusion, not less. So as Ozzie said, the government proceeded anyways. It's hard to negotiate when one side seems determined to undermine the system. The third possible outcome is the constitutional amendment, and this is a heavy hitter. John Weston argues that we need a constitutional amendment to clarify that Canadian law prevails, and that would protect every single province in Canada. We need to say, yes, we respect Indigenous rights, but we also respect the rights of everyone who lives here. We need a clear prioritization. Therefore, this might be the only real fix. And it's going to be hard. It's going to require the feds and 7 provinces to agree. But as Weston says, we can't have 2 laws, because that creates chaos, that creates uncertainty, and that creates a paradox. So, where does that leave you, the homeowner? As Ozzie called it, this is an extended existential experience. And that's a polite way of saying that we are in limbo. The main takeaway is that you should not ignore this. If you're buying, you need to be doing some historical checks. If you're renewing your mortgage, you should start early and start to contact your bank. and you need to re-educate yourself on these new laws coming out. As John Weston has a book coming out soon, and it will be called First Nations in the Future of Canada. I would definitely keep out for that and to try and understand this a little bit more to be able to survive these times. I've guided investors through the great financial crisis and COVID and numerous other crises as well. We survived because we did not panic. We just planned. And right now, the plan is caution, education, and watching cases like this. Now, if you want to stay ahead of this curve, hit the subscribe button because I'm going to be keeping track of every story coming out, including stories that the mainstream media may not be covering for you. My name is Richard Morrison, 25 years in the game, still learning, still fighting for your right to own property. I'll see you in the next one. My name is Richard Morrison, and I've been a leading investor for 25 years across the United States and Canada, closing over $230 million in deals. My clients didn't just survive the 2008 crash and the COVID crisis, they thrived because we faced the hard truths head on. And today, we're tackling the hardest truth in Canadian real estate right now.